So we're going to be talking about contingencies. And by the way, that quiz that I gave everyone, I just, want you to know. Can everybody see it says understanding contract contingencies in the California Residential Purchase Agreement?
Yes.
Oh, good. Good. So I just want everyone to know that your answers to the quiz and your score have already been sent to your respective brokers and to the Department of Real Estate. I just wanted you to know that. Some of you may be expecting a call. I don't know. Maybe not. All right. So understanding contract contingencies. So a contingency is an if, and maybe more accurately, it's an only if. I'm willing to buy your house, but only if it appraises for the purchase price or more. I'm willing to buy your house, but only if I can get a loan. I'm willing to buy your house, but only if, after investigating the property, I'm not turned off. I'm willing to buy your house, but only if I can get homeowners insurance. I'm willing to buy your house, but only if I like the homeowner association documents. I'm willing to buy your house, but only if the preliminary title report shows that the title is clear. I'm only willing to buy your house. I'm willing to buy your house, but only if I can sell my house. Right? That's what we're talking about in a contingency. And so another way to conceptualize it, you're on a boat, right? You're in the boat. It's stormy weather. And there's these escape hatches, right, which they've set up so you can get out of the boat if it starts to sink. Those are the contingencies, all right? Those are the escape hatches. Every contingency you remove, it's like nailing the hatch shut. Every time you remove a contingency, you've nailed the hatch shut. And if you've removed all the contingencies, then there is no more escape route for you. You're going down with the boat. Now, one of the questions that we already discussed is, well, if you don't remove your contingency on time, are you out of contract? Agents will tell you this. You're going to lose your deposit. They'll tell you that too. None of that is true. And even if they give you a notice to perform and you can't perform, and then a demand to close escrow and you can't close escrow because of something with your loan or the appraisal or something, that does not mean you automatically forfeit your deposit, right? The deposit going to the seller is not automatic. It will stay in escrow. The seller may have the right to cancel the contract, but the seller does not have the right to cancel escrow without the buyer's consent. And why? Because the buyer has money in escrow. So there's only three circumstances upon which the buyer's deposit would be given to the seller. Number one, if the buyer and the seller both sign a document releasing the deposit to the seller. Now, you might guess that buyers are reluctant, let's just say, to sign a document that says that the money they've been saving up to buy a house is now going to be transferred to the seller. That's, they're not going to sign it. Okay, well, then if the buyer won't release the money, then what happens? Well, you have to go to arbitration. And if the arbitrator awards the money to the seller, then, then the seller gets the money. What else? What's another possibility? Well, you go to court. And you go to court, you get a judge to issue a judgment saying that you get the money, then escrow will release the money. Until that happens, they're going to keep the money. And by the way, even though liquidated damages, which is the part of the contract that says that if you can't close, if you're a buyer and you've removed your contingencies and you cannot close, the clause that says you're going to lose your deposit, there's a word that's actually in the California Civil Code that is not in the residential purchase agreement liquidated damage section. And that word is reasonable. It says in the California Civil Code in the section on liquidated damages in real estate that it has to be reasonable. So not only isn't the deposit an automatic forfeiture to the seller, just because the contract seems to say if you stumble and fall, the seller gets to keep your deposit, it doesn't happen that way most of the time. If the seller can sell the property for an equal or greater amount, the seller has no damages and they're not going to be allowed to keep anything. Right? If they sell for less, now maybe they can make an argument. It's not so easy to get the buyer's deposit. Right? Just saying. All right. So the primary contingencies, I've rattled most of them off. We're going to look at some of them in the forms that you would use. And those are references to the pages in the purchase contract. The non-optional and statutory contingencies. So if the contract says that in the removal of contingencies that the buyer and the seller both have to use good faith, what would that mean? Well, let's say I know, in fact, I had a listing and the buyer was trying to wiggle out, but they had an investigation contingency, but they didn't have a loan contingency. They didn't have an appraisal contingency. And so the buyer's agent sends me an email that says the buyer's backing out. Why? One, because the backyard was not big enough for a kidney-shaped pool. Two, that the 3-car garage is really 2.5, but not really quite 3. That's what they said. Now, the reason why that wasn't a strategic approach is because the backyard they saw when they looked at the property, they saw the garage when they looked at the property. If I had given them a termite report before they made the offer and it said $5,000 worth of termite work, then they knew that also before they made the offer. So what's considered good faith is that if you only make the decision based upon information you've obtained after you're in contract, not something that you already knew, and now you're using the investigation contingency to get out. Does everybody understand that you're supposed to have a new reason? However, the TDS is an exception. So what I mean is, let's say the contract says that the TDS and the SPQ, the seller property questionnaire, all questions have to be answered in order for those documents to be complete. That's what it says. Now, there's actually a difference between what happens with the TDS and SPQ. If the SPQ, the seller property questionnaire, doesn't have all the answers, they skipped some of the questions. Well, the SPQ is not a statutorily required disclosure. It's not. It's a contractual disclosure. Therefore, it would have to be in good faith. For example, I had a case where our seller didn't answer every question. The buyer wanted out, but they didn't have any contingencies. They noticed that we didn't answer all the questions. They then forced by a notice to perform that we finish answering the questions. It says in the purchase agreement that if the seller amends the SPQ, the buyer has 3 days to back out. We amended the SPQ, but the answers were no. In other words, nothing was there, right? They just missed it. There wasn't anything that they were hiding. Then when the buyer said, okay, we're going to back out, no, that's not in good faith, because our answers did not give you more information about the property, right? You just are trying to weasel out. The TDS is different because the TDS is a statutory disclosure. And the civil code says if it's amended, you have 3 days to back out. And there's no mention in the civil code that it has to be done in good faith. So and by the way, if I've got an agent with a buyer and the buyer wants to get out of a contract and they've removed their contingencies and they ask me, how can we do this? First thing I do is say, show me the TDS and the SPQ. Show it to me. And then I'm going to go through and look and see, did they miss anything? Just even one box, just didn't check it. Oh, if it's a TDS and they missed something, we'll make them complete it. and then we'll cancel and we get our deposit back. Does everybody understand that there are some non-optional statutory contingencies? The natural hazard disclosure is a statutory contingency. Lead-based paint is a statutory contingency. So what is the removal process? Well, we use the form C.A.R. to remove it. That's what we use. Cancellation, buyers must act in good faith when canceling under a contingency. That's what I said. Sellers must follow the NBP or DCE process. And then it's formalized in Form CC. All of these I've given you samples because why not? The legal rights, if the seller cancels in bad faith, you can sue for specific performance, which means to force the seller to go through with the sale. Recourse for inaccurate disclosure, sellers must amend disclosures. If they discover inaccuracies, buyers have 3 to 5 days to cancel once any of these have been amended. Repairs and refusals, sellers. So how many of you think it's good strategy if you're representing a buyer or seller to make sure that in the offer or counter offer, it says as is? We're buying the property as is. I'm selling the property as is. Is that an important thing to include in an offer or a counter offer? Anyone want to? I think there's some chat. Another thing I don't see very well.
Everything is usually as is regardless.
Very good, Michael. So the residential purchase agreement already says that this is an as-is contract subject to buyer's inspection rights. It already says that. So what does as-is mean? It means that the seller doesn't have contractual warranties to fix the property. Now, a long time ago, right, in a land far away, the residential purchase agreement in California contained a list of what were called seller warranties. They were: 1, the seller is going to give the buyer a Section 1 termite clearance. Number 2, there would be a 1-year leak-free warranty on the roof. Number 3, any plumbing leaks would be fixed. Number 4, broken and cracked glass would be replaced. Number 5, personal property and debris, and there were more. So the seller started out with an obligation to fix stuff. That doesn't exist anymore. That's what as is means. But it doesn't mean that the buyer can't ask for stuff to be fixed. Well, it said in the MLS that the seller's not going to fix anything. I understand. And they, in the counteroffer, they said seller's not going to fix anything. I understand. Well, what should we do? Ask the seller to fix it. Well, they said that it doesn't matter, right? Because we can use a repair request and ask for a credit. It doesn't matter, right? That the seller doesn't want us to. We can still ask, because if they say no, then we can cancel the contract based upon the inspection contingency. And by the way, if you cancel the contract within the contingency period, based upon the contingency, you get your deposit back. What if you're the buyer and you don't cancel within the contingency period? Do you get your deposit back if you, like, 3 days, 5 days after the inspection contingency is come and gone, do you still get your deposit back? Anyone want to?
Yes, you do.
Yes, you do.
Yes, you
So,
still have your loan and your appraisal, and then you have your natural hazard. You have your Megan's Law.
well, let's say that we decided we removed all those. The only one we have is the inspection contingency, and we just are nervous that it's going to take a lot to repair, and we just don't remove it. And then the seller says, notice to perform, here it is, 2 days. 2 days comes and go, we still haven't removed it. So now the seller's canceling us because we didn't perform within the 2 days. we're canceled by this, do we get our deposit back?
Yes.
The answer is yes.
Yes.
When do you lose your deposit? Only if you've removed your contingencies and still can't close. And then only if it's a reasonable damage. So what is how do you, because this is all about cancellation, you would confirm the failure to perform, you would issue either the notice of the buyer to perform or the notice of the seller to perform or the demand to close escrow, which if there was something else, you wait for the time frame. How long is the demand to close escrow time frame? Very good. I heard the shout of all the answers, 3 days. It's 2 days for the notice of the buyer to perform, 3 days for the demand to close escrow. You would, and if it goes, nobody wants to do this. By this, I mean hire lawyers and go to arbitration or to a court. You understand? Nobody wants to do this. Seller doesn't want to do it. The buyer doesn't want to do it. And if the buyer is saying, we're not going to cancel escrow, we want our money back. If you're going to keep our deposit, you're going to have to hire a lawyer and we're going to have to go to an arbitrator. A lot of times sellers will just say, okay, get lost, and they'll get rid of it and remove and give you back your deposit. All right. These are the forms we're going to talk about. This is the grid. So this is what the residential purchase agreement section on contingencies. And you'll see there's L1, which is a grid reference, and A8A is a paragraph reference within the residential purchase agreement. So here's the list. Right. There are some other little ones, but this is the big list. Loan, 17 days after acceptance, or no loan contingency. You have to remember that this is a balancing act. Who gets to buy the property? Usually it's the buyer with the highest non-contingent offer. Now, if you're in the San Francisco Bay Area, particularly if you're in Silicon Valley, it is more common that the seller is going to have a property inspection, a termite inspection, a roof inspection. They're going to get estimates from the different contractors. They're going to do the TDS, the SPQ, the agents, AVIT, everything. And they're going to put it in a disclosure package and give it to the buyer in advance of the buyer making an offer. And when the buyer does make an offer, they want the buyer to initial that they've received all this stuff. And the reason they're doing it is because they want offers to not have that contingency. So, all right, if there are 2 offers and one of them has a loan contingency and the other one does not, and they're both for, let's say, 800,000, which one is the seller going to take? The one without the loan contingency, If the one with the loan contingency was $20,000 higher than the one without the loan contingency, which one will the seller take? And the answer is most likely the one without the loan contingency, because the loan contingency is a really big if. And what the listing agent and seller are thinking, why didn't you get pre-approved? You sent us a pre-approval letter. Well, if you're pre-approved and this is a real pre-approval, why do you need a loan contingency? If there are issues, you don't want to remove the loan contingency, right? And you have to have a heart-to-heart with your loan agent and say, we're about to remove the loan contingency. How sure are you that this loan is going to go through? And the lender might say, I'm sure this is as solid as you can get. You could check the box, no loan contingency, appraisal. So the default contingency is it has to appraise for the value of the property or more. If it appraises for less, this buyer has the right to cancel the contract, get their deposit back. Buyer also could say, it's not too far off, I'll go with it anyhow. They could either enforce it or waive it, the contingency. Let's say now the buyer is saying, now in Silicon Valley, it's also common to make offers without an appraisal contingency. And again, if you're the seller and there's two offers and they're both 800,000 and one has an appraisal contingency and the other one does not, you're going to go with the one that doesn't have it. What if the one with the appraisal contingency is $20,000 more than the one without the appraisal? You're still going to go with the one without the appraisal contingency. What does it mean, however, if we make an offer for $800,000 and there's an appraisal contingency, but it only appraises for $775,000? What does that mean? It means the buyer has to come up with the extra $25,000 out of pocket. Does the buyer want to do that? Does the buyer have the money? This is a conversation to have. Now, if I'm talking to a member of my team and they have a buyer and they're going to make an offer, those of you that have had this experience more often than others know I generally ask exactly the same questions. Question number one, how long has this property been on the market? Question number two, are you expecting multiple offers? Now, if they say, well, it's been on the market 3 days and the open house is like an anthill and the listing agent won't even call us back because their line is always busy. Okay, we have multiple offers, which remember, if there's multiple offers, the highest one without contingency is probably going to get it. But let's say, well, it's been on the market 35 days. Is there a set date for offers? No. They say they'll take them as they come. Great. Let's make an offer and keep the appraisal contingency. Because what I tell buyers is, when they're worried about the price, I'll say, why don't we offer list price? We know they'll take that. So we offer list price, but we have an appraisal contingency. That's a safety net. Because the lender who's putting in more money than you are is going to send an expert conservative to go look at the property and determine what they think the value of the property is for loan purposes, and it either will or will not appraise. If it does appraise, then you can sleep comfortably knowing that the price you paid is a fair price as confirmed by the appraiser. And if it doesn't appraise, you can renegotiate the price. And if the seller won't renegotiate the price, you can cancel and get your deposit back. Again, whether you have it or not, and by the way, if your buyer says, well, I could throw in an extra 10 grand or something like that, but that's about it. Then in this here where it says appraisal, see, and there's a little box, we can check that box and write in, like in my example, $790, right? If the buyer says, I'm willing to put in another $10,000, okay, it has to appraise for at least, we're offering 8, but it has to appraise for at least $790. This is called a gap clause. Investigation of the property, this is the big one. And those of you that are not in Silicon Valley and you're in a situation where you rarely have termite property and all the inspections and reports in advance, if you're representing the seller, you're making a mistake in my view. Because what will happen when I hear that we're writing an offer on a property and they don't have a termite report and a property inspection, I'm thinking, goody, this is good. Yes, the buyer is going to have to buy one, but it's going to give the buyer a get out of escrow free card. That investigation contingency, this is exactly what it says in the RPA. The buyer's acceptance of the condition of the property and any other matter affecting the property is a contingency of this agreement. That's what it says. Now, that's a pretty much, if I decide I don't like the house, I can cancel the escrow almost. Now, 17 days, again, that's the default for everything. Does it take 17 days to get a property inspection, a termite inspection? No. Could you do it in 10? Probably. The shorter we can make contingency periods, the more attractive our offer is to the seller. What about homeowners insurance? That's another contingency. You should have your buyers talking to insurance people. And by the way, it won't take them very long. If you give them an address, they'll give you an answer very quickly as to whether or not you're going to get insurance at all and how much it's going to cost. But you have 17 days to work it out. That's a new contingency. Review of seller documents, the TDS, the SPQ. Now, if they give you the documents after the contract's been accepted, then you have 17 days or 5 days after delivery, whichever is later, right? That's if they give it to you after you're in contract. But if the seller gives you all of the seller documents before you write the offer, you have no days, no days, right? You've already read them. That's it. Preliminary title report, 17 days or 5 days after delivery. Common interest disclosures, also known as homeowner association documents. Review of leased or liened items. Biggest one we see is solar panels. If you're selling property up in the hills, there's septic tanks. I mean, not septic tanks, propane tanks, satellite things, but most of it is solar panels, and they're either leased or they're lien. I have another video on solar panels. It brings up a whole bunch of other issues, a whole bunch of them. And the weird thing about this particular contingency, it's the only one that works both ways. So all of the other contingencies are either a buyer contingency or a seller contingency. The review of leased or liened items says that let's talk about leased items, that the buyer's acceptance and ability to take over the lease is a contingency for both the buyer and the seller. So if the buyer says, I'm not going to take over the lease, then the seller can cancel. If the buyer says, I don't want to buy, and because I don't want to take over this lease, the buyer can cancel. But either side can cancel if you don't accept it. And the big one in terms of dragging down the transaction is that if they have to sell the buyer's property first. This is another reason to talk to Matt at Envoy Mortgage, because there's one of our, solutions is how you can get a loan so that you can make an offer that's an all-cash offer without making it contingent on the sale of the buyer's property. All right. So there's a little checklist. Does that look nice, right? For what you would be looking at in a very short way for the different parts of this. Let me see, how am I doing? This are the relevant sections. This is the one that goes through the list and gives you more information. Rarely do clients ask about this, but if you want to read it, there it is, and it goes all the way down to, leased and lien items, removal or waiver, whatever, they're all here. Removal of consent, and I'm not going to read them to you. Buyer's investigation of property and matters affecting the property. This essentially says the buyer can get any kind of inspection they want. I've had people get asbestos inspections, radon gas inspections. I've had people bring mystics, psychics, and other spiritualists to see if there are evil spirits in the property. I'm not kidding. All right, you can do whatever you want as long as you don't break anything or create a lien on the property. And so then when I see, agents writing in, buyer has the right to get a termite report, it already says that in the contract. See, I have this theory, which is we shouldn't write in stuff that's already in the contract. If the contract already says you can do this, why are we writing it in? And sometimes we do it just to make a client happy. But that explains it. This is the title investing. Did I hear somebody?
You're muted.
What? I hear noises. Somebody's asking if we would share the document again. anyhow, that explains the different contingencies. And I just wanted to drop this in so that you could read them. It looks like I may have included a little more, but it goes through the cancellation process. One of the things that I like to point out when it comes to definitions and instructions is the counting of days. And what that means is that we are always counting calendar days unless we're talking about putting the deposit into escrow, which is 3 business days. But everything else is calendar day. People are still looking for the copy of the handout.
Michael, is it the one that you sent to me, understanding common contingencies? Because you
Yes,
didn't paste
I-
anything yet.
I don't think it's any different,
Okay, I'll add it.
and I pasted it in at the beginning. But then
I don't think I was on yet.
was here when I did that. All right. So, I'm assuming that can be handled. Notice it says in J, days means calendar days. However, delivery of the deposit is based upon business days. If it falls on a weekend or a holiday, it rolls over. So when we're supposed to remove contingencies on Friday, and my agent is saying, oh my gosh, we don't really want to remove the contingency. We don't have an estimate yet for this. When do you expect to get it? Oh, we should have it on Monday. All right. So we don't, first, do not remove the contingency. Right, don't do it. Well, but the agent told me that if we didn't remove it on Friday, that we would be out of contract and lose our deposit. Don't believe them. They're lying to you. It's not going to happen. So what happens if on Friday you don't remove the contingency? They give you a 2-day notice to perform. Saturday, but Sunday's a weekend. It's not a business day. It means you're back to Monday. When on Monday, midnight on Monday, is when the deadline is. Oh, well, you've just bought yourself a few extra days. Now, I'm not saying this is a good thing to do, but you have to realize that this is like playing chicken, where they would drive their cars at each other. And what I mean by that is, what can the seller do if the buyer doesn't remove contingencies on time? Well, they can give them a notice to perform and then the demand to close escrow. They can cancel the contract and give the buyer their deposit back. That's all they can do. Does the seller want to cancel the contract and give the buyer the deposit back? No, they usually don't want to. Right? They want you to close. So don't remove contingencies just because the listing agent is insisting and threatening and telling you how long. I always love it when they start off with me by saying, I've been in real estate 10 years. Really? Woo. I'm impressed. It's still wrong, right? Read the contract, right? All they can do is cancel you, give you back your money, which they are going to be reluctant to do. Investigation, advisory, I actually go through this with buyers. I know, because these are the different things that the buyer is going to want to look at. Homeowner insurance advisory, that's one of the contingencies. Contingency removal. Wow. There are 3 ways of removing contingencies. Number 1, which is paragraph number 2. And the number 1 way is you only remove specific contingencies, one at a time: loan, appraisal. Now, loan and appraisal you can do in the purchase agreement. But those are the only 2 contingencies that you can just remove in the purchase agreement. You can check a box that refers to this form and you could give it to them and remove your contingencies. But those are the only 2 you can just check boxes in the RPA. So you could go through and remove this one, that one as you go. That's better than nothing, but not exactly what the listing agent wants. Second choice is removing contingencies except. So you say, we're going to remove all our contingencies, except the loan contingency, or except the appraisal contingency, or except the insurance contingency. Now, you'll notice the inspection contingency, the investigation contingency isn't there. sometimes we have to click on other and write it in. This is better than removing a few of them at a time. And then from the seller's point of view, they really want the last one, which is paragraph 4, but really the third way, which is when you check that box, you're removing any and all contingencies. In the contract, in the escrow, before it closes, this form should be completed and in the file. You want, or they have to have checked all the boxes along the way. You want the removal of any and all contingencies. Contingency for the sale of buyer's property. The reason this is so bad, I'm going to use that word, challenging, is the question is, has the buyer put their property on the market yet? Yes or no? If the answer is no, we just saw this house and we wanted to buy it, so we're going to get hurried, we're going to hurry up and sell our house. So you haven't even listed it yet? Not yet. Oh, that doesn't sound good. What if they listed for a price that's unreasonable and it never sells? So we haven't even listed it yet is the bottom of the ladder. We've listed it already. That's a little bit better because they're obviously, hopefully prepared to sell. We've listed it and we have an offer and we're in escrow. Well, that's even better. We've listed it, we have an offer, we're in escrow, and they've removed their contingencies. At which point I would raise the question, why do we even need to make ours contingent if there's no more contingencies on the sale of yours? Does everybody understand that? And I've made another video. I'm going to go through this probably as a standalone because it's so much fun to go through this form and all the good stuff that comes up with it. Non-contingent offer advisory. This is basically telling buyers not to buy a house without contingencies. And what I say to them, like this is more of a Silicon Valley thing because we usually have all the inspections and reports. This is what I say to buyers. Lawyers suggest that we let you write contingent offers, which, considering that you want to buy homes that have recently come on the market where there's a lot of competition, what that means is that there's going to be multiple offers. And what that means is you're not going to have any of your offers accepted. All right, this is what the lawyers say. I'm supposed to let you fail, lose houses, and then self-discover on your own. Maybe we ought to be removing contingencies when we make an offer. So how do you want to proceed? Do you want us to go ahead and write offers that I'm pretty sure will never be accepted? Right, just to get into the practice. Or do you want me to suggest what we might need to do to compete, given the fact that this is a hot property and there's going to be multiple offers? And they always say, tell us what we need to do. And what that means, even though it says we're not doing this, right? Notice it says we're not recommending that you don't write contingent offers. We are kind of recommending they're writing non-contingent offers depending on the property. There's really only one seller contingency. And the seller contingency is I don't want to sell my house unless I can find another house to replace it. All right, so that's pretty much the only real seller contingency. Buyer inspection waiver, if the buyer says, I don't want a property inspection, the seller doesn't have any, and the buyer says, I don't want any, we want them to fill out this form, which basically says, you ought to get inspections. And I know the buyer inspection advisory already says that, but here we're going to make them initial that we told you to get a home inspection and you won't do it. We told you you should get a pest inspection, a termite inspection, and you won't do it. We told you that you ought to get some other inspection and you didn't do it. It is not our fault if you're later unhappy. Because what will happen is they'll say, well, they never told me I should have gotten a termite inspection. I didn't really understand what it was. They just made me sign everything really quickly. So I don't know. If they are, so this form we use just so that they have less opportunity to blame us when they chose not to. This is what the notice to perform looks like. Notice there's all these boxes. Again, this would take longer for me to go through all of them, but you can see some of them. Here are all the contingencies, and here are contractual actions, which are another thing you can make. Let's say the buyer doesn't put their money into escrow in the first 3 business days. What if they don't? They don't do it. You can give them a notice to the buyer to perform. You would check initial deposit under contractual. What if they still don't do it? You can cancel the contract. Move on. Notice the seller to perform, same idea. There's just oftentimes less. If the seller won't give us the TDS, the seller won't do something. They won't give us the fire hardening. This is the list of all the things that sellers and their agents sometimes just don't do, which are required in the transaction. And if you would, if they don't give it to you, you would be giving them this and a demand that they turn over all the stuff. A demand to close escrow, 3 days. The notice to perform is 2. This is 3 days. You give them the notice to perform. They don't perform. You give them the demand to close escrow. You give them 3 days. They don't close in 3 days. And we're now to the cancellation of contract and disposition of the deposit. And they've sort of broken it up to make it a little bit easier. But these are the different reasons that you could cancel. And then the next section is what's going to happen to the deposit. Is the buyer going to get it? Is the seller going to get it? Are they going to split it? There is no deposit. There is no deposit if they never put the money in. And again, that would require a longer discussion for me to go through all that. Any questions about that? Did I miss something? Did everybody get a copy of that?
Michael, I have a question
Oh, good.
regarding the appraisal contingency. So if somebody puts an appraisal contingency and then it doesn't appraise, is the buyer obligated to negotiate the price down, or can they just back out without
They
negotiating?
can just back out. And related to that, because this is a common question I get, does the buyer generally have to turn over an appraisal to the seller?
I think no.
And the answer is no, unless the buyer has an appraisal contingency and they're using that contingency.
Mm,
We don't take the buyer's agent's word for it, that it didn't appraise. Right. We're not.
got it. Thank you.
We want to see a copy of it. All right. Otherwise, so Trizia, if buyer cancels, seller agrees to return deposit, does escrow have to return the deposit and close that escrow before seller can relist the property? Yes and no is the answer. And the reason I say yes and no, the escrow company won't have 2 open escrows on the same property. So if the seller had open escrow with Chicago Title and you're fighting over the deposit, Chicago Title's not going to let you create another escrow they won't let you do it. First American will, right? Fidelity will. All of the other title companies would be happy to talk to you. You don't necessarily have to tell them, but you'd have to open up escrow at another title company. All right. Now there's a risk, right? Because if the buyer is arguing you didn't have a right to cancel me and they get a lawyer and they're suing for specific performance while you're trying to, it's complicated. Also, listing agents, we all tend to be protective of our title company. And we're reluctant, we don't want to switch title companies. And it's way cleaner to close it out and move on than open with another one. Other questions?
Not a question, but a statement. Observation would be a non-licensed person to do a transaction is a disaster for everyone.
What would be a non-licensed?
That would be for sale by owner. That
would
be trying to do it on their own, and they have to provide everything, and you're doing both, but they don't want you to represent them, and it becomes a complete mess. That's my observation.
Right. Well, yes, you are correct. This is why it's a hassle to work with for sale by owners, because all of those legal statutory those are all required, whether it's a for sale by owner or not. They're not exempt. Right, but then they don't know what to do. So we have to help them. Trizzy asked, would the second escrow have to be disclosed? We usually do not. Because the second escrow company, some of them care, some don't. Some of because escrow agent, the rep from the escrow company is a commissioned salesperson. So do you think they're going to just say, oh, no, we don't want your escrow? Unlikely. Right, and if you tell them, well, we want to switch from Chicago to, to you guys, they're usually saying, wonderful, great, cool, right? But then the reason the escrow company might be nervous if they know that you've got a second one going is that what if there's lawyers that get involved? And, because you're still fighting over the other one. All right, any other, questions? Well, that was fun. So, probably next week we're going to talk about disclosures. Does that sound like fun? The TDS, the SPQ, the AVID, and all of the other fun ones that we need to use. And if you have any questions, let me know. Bye, everybody.
Thank you.